The cases regarding ruling of Copal Partners Limited, so ITR 359, Equity Trust Jersey Limited AAR and Abu Dubai Investment Authority AAR. We will read the exact case. Section 9(1), income deemed to be accrued and arise in India. Representative assessee, or a trustee or business connection or a British Virgin Islands by the company registered in Jersey, trustee in Jersey, becoming a sole beneficiary. Prior to make investment in India, foreign trust is recognized by the Indian Company Limited, arranged for the purpose of commercial expediency. Income that accrue to the trust would not be chargeable to tax in India, either by virtue of application of Section 61, read to Section 63 and Section 161 of the Act, conjointly for provision Article 24 of DTAA. Income accruing and a ruling of AAR was quashed, and DTAA income India versus UAE Section 5, subsection 2 of 1023 of B, 61, 62, 63, 90, 160, 161, 245O of Indian Trust Act 1982. This was the thing. And read. SSC filed a return of income in India. Okay. Disclosed therein income that falls within the scope of Section 5, subsection 2 of the Act, but in the view of exemption available in the terms of DTA or DTA exemption available. Reported nil taxable income. Okay. The assessee did not have any permanent establishment or fixed place of business or any other form of presence in India. Did not have any business connection or operation in India. They gave all the connection. It's a very good point, you should see. How you say, wait, wait. Um, mm, this point. The assessee did not have any permanent establishment, fixed place of business. No. Have any permanent establishment, a fixed place of business, or any other form of presence in India, and did not have any business connection operation in India. This is a very good point you can give in it. So this way he say that his income doesn't accrue and arise in India. Then what? Mm, According to the assessee, income derived from making investment and debt security in India. So investment in shares and debt security they bought in India was not accessible to tax in India. And regarding to the provision of Article 24 of DTAA, read with Section 61, 60, 161 of the Act. So even though income accrued arise in India, there is no permanent establishment in India. That income is not taxable as per the DTA. Okay. As he applied to the advance authority of advance ruling, Constitution under Section 245(o) to give ruling on the question. Authority held that the trust was registered in Jersey, not in India. There is no treaty between India and Jersey. Okay. In Section 61, 63 of the Act would apply only to the trust which fall under the Indian Trust Act 1982. Okay. Trust did not meet the definition, characteristics, and features of trust as per the Indian law. India had not ratified the Houch Trust Conversion, July 185. Hence, trust law of foreign jurisdiction were not applicable to India. Important point, very important. Very important point. What is that point? Is so. First, the Houge Trust Convention of 1st July 1985. Hence, the trust law of foreign jurisdiction were not applicable in India. Very good point. This is then right. The settler would not be a sole benefactor. Settler would not be a sole benefactor. That also saying okay. Section 60 to Section 64 was designed to overtake the circumvent the counter designed by the taxpayer to reduce the tax liability by parting with the parting with the property in such a way that the income would not no longer be received by him, but at the same time it is retained retains a power over the property of income. So what they are saying is the income is designed in which it is not to say so his property and no longer. Okay, it's a manipulation. So section 161, 1 and 1 and 4 provides that the trustee of the representative assessee, in the case a trustee being a resident of Jersey, would not be agent of the assessee. No authority and material had been placed before the authority to suggest that the provision of section 161 would be applicable to the foreign trust and trustee. Assessee representative would not be satisfactory answer to query as to why the assessee would likely to obtain the investment of non-convertible debenture fund through Jersey route for investment in India market. Necessity itself being registered for an institution investor could have directly invested in the Indian portfolio and take advantage of the Article 24 of DTAA. Yeah, directly they have invested. They are not required to do the Jersey route. As assessee was received the income through a device and not from the direct or immediate receipt of the income received from Indian debt investment was not derived from the assessee and did not fall under the Article 24 of DTAA. Okay, thus was proposed amendment. It has come to its effect. Article 24 of DTAA. Article 24 of DTAA. Same time, if there is a proposed if there is a proposed amendment, it was come into effect by the April 1, 2021, which suppose a view that the entity is a resident of UAE, and therefore the entity of assessee was in receipt of some income, then the income would be exempt from the tax under Section 10 of the Act, and the proposed amendment suggested that the indirect accrual of income is not eligible to treaty benefit. Oh, they are saying that directly if they received in Dubai, it's no problem. That's indirect accrual is not treat benefit, they said. On the writ, allowing the petition of the court held that the income earned through the assessee's investment in Indian debt portfolio directly would have been exempt under Article 24 of DTAA. The assessee was registered as the foreign institution investor and later foreign portfolio investor with the SEBI. Okay, the deed of the settlement with ETL regarding the trust. The assessee had made the capital commitment of 200 million in the trust and capacity of the settler of the trust. The ETL was USD. ETL was a trustee of the trust and the assessee was also the sole beneficiary of the trust. The trust was registered in the foreign portfolio investor with SEBI. Section 61 of the Act provides that any income arising to any person by virtue of recoverable transfer shall be chargeable to tax as the income of the transferor. So, by virtue of the recoverable transfer shall be chargeable to tax as the income of the transferor. Transferor, okay. A deed of the deed settlement and particular clauses from the deed of settlement shows that there were recoverable transfer by the settler. That is, assessee of the trustee ETL was such a any income arising to the arisee shall be chargeable to the hand of assessee. The word trust in section 63 covers all trust within this ambit. Okay. The how trust contains does convention does not decide the issue one way or other. There was nothing to even suggest in the ruling of authority how the rectification of how you trust conversion would affect the status of foreign investor trust in India. Even the foreign trust in India under this Act of Income Tax Return forms and prescription under the Act require the details of trust created under the law of country or country outside India. The trust created in terms of the deed settlement was consistent with the both requirement of both Indian Trust Act as well as the Trust of GOC Law 1984 as that the constituted trust. The Act does not make any provision that the settler cannot be a sole beneficiary. Act does not make any provision. Secondly, there is no provision under the Indian Trust Act which debars a settler from being a beneficiary. Very good point. So, secondly, there is no provision. And secondly, there is no provision under the Indian Trust Act which debars a settler being beneficiary. In the present contention, present insistence that the settler was not a trustee but also the sole beneficiary, which is clearly permissible. In the assessee had invested the amount directly, the income derived from such an investment should be exempted under the Article 24 of DTA. Assessee had not created the trust to avoid tax. The assessee had routed the investment, certain investment through the trust only by a commercial expediency. Assessee had explained in detail that authority why it was routed its investment in non-convertible debenture through the Jersey route for Indian markets. The Act did not provide anywhere that only a trustee who is a resident in India can be an agent under Section 160 of the Act. Very good point. The Act did not say. The Act does not pray anywhere to provide that trustee who is a resident of India can be agent under 116. It didn't say that. Even if the trust was based on Jersey and the trust was settled in Jersey, the assessee being a settler of sole benefit of trust and president of UAE in terms of Article 24 of the DTAA, income which arose by virtue of investment in India portfolio companies would be owned by the beneficial provision of DTAA. It takes further, even if the trust structure was to be discarded, it must necessarily follow the investment and must be regarded as being made by assessee, and hence the income would arise in hands of assessee. As the income would not be taxable in India by virtue of the provision of the DTA. Therefore, no attempt whatsoever to reduce the tax liability by using a trust structure. There's no attempt whatsoever to reduce the tax liability in tax structure. When the provision of the trust be provided, the assessee has a right to resume the power over the entire income arising on the investment and may the trust in the portfolio companies. The entire income arise from the terms of Section 61 of the Act passes the assessee in the hands of assessee. So the entire income arising therefrom had in terms of Section 61 of the Act to be assessed in the hands of assessee. This means the exemption of Article 24 of DTAA would be attracted. So even if the income is taxed in the hands of the trustee, the terms of Section 161 would be taxed in like a manner as the same extent as a beneficiary. Once again, the assessee was like a sole beneficiary of trust, and the income assessed in the hands of trustee would take color of the assessee's income, and thereby benefit of DTA would be granted. The assessee could reassume the power, and hence a contribution to the trust was revocable transfer, thereby making the income arising to the trust taxable in the hands of assessee. This is exempt under Article 24 of DTA. In the circumstance, the ruling dated 18 March 22 had to be quashed, and the income that accrued to the trust would not be chargeable to tax in India either by virtue of application of Section 61 or read with Art Section 63 or Section 61 of that conjointly the provision of Article 24 of DTAA since the ruling was quashed and steps taken in further of the ruling order past them was quashed and set aside. Wow. So the income which is arrayed by way of trust is not in the hands of trust, it is on the hands of the individual. What is the investment they made? Around $200 million. Oh, $200 million what the investment made is not taxable. Very good judgment. Very good judgment. So they are quoting these sections. What are section 160, article 24, 61, 161. So 63, 61, and 161 of the Act and conjointly the provision of section 24 of the DTA. Everything is included. Very good. Very good.